Halfway through questioning this particular doctor in a medical malpractice case in his pre-trial deposition, he kept saying, "I've asked and answered that question, counselor. Ask me another question." Over and over again, he kept giving me that answer. What did I do in that instance? You want to know what I did? Come join me on this walk through the neighborhood as I share with you exactly what happened. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, this is a medical malpractice case. My client sued her doctor claiming that he was careless, causing her significant harm and injury. And during the course of her lawsuit, I had an opportunity to question the doctor whom she was suing. And this is being done in his attorney's office, in this conference room. Now, you should know something. There's no judge there, and there's no jury there. Instead, it's just me, it's the doctor, and the doctor's attorney, and a court reporter, also called a court stenographer. And the purpose of the court stenographer is to record all of my questions and all of the doctor's answers. So now, during the course of my questioning, you know what happened? The doctor, halfway through the deposition, turns to me and says, "Excuse me, Mr. Oginski, I've already answered that question. I'm not answering it again." So you know what I said? I said, "Doctor, I didn't ask you that question. I asked you the variation of that question. So now, if you could please focus on the question that I am asking, I'd appreciate an answer." He said, "No, I answered that already." So what do? Do I sit and argue with the doctor? No, you know what I do? I'll ask another question. And he turns around and says, "Excuse me, but I answered that question already. I'm not answering it again." So now we're going back and forth, and I'm changing up the question repeatedly. And now the defense attorney is getting in on the act. The defense attorney is now saying, "I object. This question was already asked and answered." Now, is that really a valid objection during the course of questioning, during a doctor's pre-trial deposition? The answer is, it could be. Meaning, if I've already asked the doctor that exact question, and the doctor has given me an answer, now he's given sworn testimony about what that answer is. There's really no reason for me to ask that same question over and over again. It would be silly, hoping to try and get a different answer from the same question. No, that's not going to happen. But I can ask variations of the question. And each time I ask a variation, it doesn't mean that the doctor gave me the same answer. I might be looking for a slightly different answer. I might be looking for something else, but the doctor or his attorney perceives that this is the same exact question. Even if the attorney and the doctor perceive that this is a similar question, does the doctor still have to answer the question? The answer is yes, he does. You want to know why? Because this is a discovery tool. We're trying to gain information to learn exactly what he did and why. And the law in New York basically says, listen, I can ask the doctor lots and lots of questions about what happened here in this case and why he did what he did. Yes, it may not be a perfectly worded question. It may be similar to the one that I've already asked and to which I've already gotten an answer, but the doctor is still required to answer the question. So even though the doctor may think it's the same question, I guarantee you that there will be slight differences, and it may be important differences. And the doctor may not realize or understand why I'm asking it multiple ways. You will find that some attorneys get so frustrated when the doctor doesn't give a straight answer or give a response to their question. They think that they are the authority and now they're asking the question and that the doctor has to answer the way they want him to. No, that's not how it works. That's not how any of it works. Instead, the doctor should be answering your question. And yes, the way in which you phrase the question does make a difference. If the defense attorney says, "Objection, I have a problem with the way you phrase that question, please rephrase it." You know what I'll do? I'm not going to sit and argue with the attorney about how I phrased my question. Instead, you will find that the best attorneys in New York turn around and say, "Fine, I'll rephrase the question," because I can rephrase the question 5 different ways, 10 different ways, 20 different ways in order to try and get a response. And so that's exactly what I'll do. I don't need to sit and argue with the attorney, but you'll find that some attorneys have nothing better to do than to sit and argue. And that wastes so much time and effort and energy, and that time could be better spent changing up your question. So you'll find that the best attorneys are able to easily ask variations of a similar question to try and get the answers that they're looking for. So why do I share this quick information with you? I share it with you just to give you an inside look behind the scenes of what really happens when we have an opportunity to question the doctor whom you are suing in a medical malpractice case in New York. You know, I realize you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.